Welcome, everyone. I'm Mike Annis, partner in Husch Blackwell's Intellectual Property Group and lead of our Animal Health and Production Initiative. For those of you that don't know me, my practice focuses on trial work, including issues involving false and misleading advertising. Before we begin, I need to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for you to use during the program today. If you have any questions during the webcast, please submit via the question box. We will answer live questions today at the end of the program. We truly appreciate audience participation. And if a fuller answer is needed or we run out of time, we will answer your questions later by email. This program has been approved for those of you that need it for continuing legal education hours. So to report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be mailed to you tomorrow, along with a recording of the webcast for watching and sharing with others. Towards the end of the program, we ask that you please complete our short survey. We use your feedback to plan future programs and hopefully tailor them to be applicable to your business. So that's it for the housekeeping, and let's get started with the program. Today, in our intellectual property seminar series, we're presenting on false advertising claims and defenses. Our goal today is to go over those types of advertising and promotional claims we've seen most prevalently over the last 24 months or so. We hope to give you insight to evaluate your current and planned marketing to try to avoid claims. And if they do come, to place you in as good a position as possible to successfully address those claims. We're also at the end going to give you a glimpse into the future, gaze into the crystal ball, our crystal ball, and outline those types of claims that we anticipate maybe aren't here yet, but are on the horizon. And again, hopefully help you to get ahead of those types of claims. So I want to introduce my co-presenters now. I'm lucky enough to be joined today with two very talented young lawyers, Emily Lyons and James Funk. Emily guides clients on complex regulatory issues as they bring dairy products, beverages, fruits and vegetables, processed foods, alcohol beverages, and other agricultural goods to market. Emily focuses on compliance matters, including labeling, marketing, permitting, and agency inquiry. Her focus today will be on labeling and marketing claims specific to what we call highly regulated industries and how to comply with regulatory requirements to help you actually avoid claims. James specializes in class action and multi-district commercial litigation, where he has pressed clients' cases in both state and federal courts. A large portion of his practice is concentrated in the healthcare space, but he's also handled claims in a wide variety of injuries, including sporting goods, food production and distribution, and cosmetics. James's angle here today will be to give you kind of the preventative maintenance tips and how to navigate claims once they're made. So, what do we mean by false advertising? Well, in gross, it's any publicly circulated advertisement containing false or misleading statements made to promote the sale of goods or services. These types of claims are, direct to really any publicly facing statement, whether it's in labeling, advertising, even talking about websites and social media posts. Although there are several usual suspects in the field, in fielding these types of claims, there really is no industry that's completely immune from them. If you're selling and advertising goods or services to the public, you're in play. Emily and I talk a lot about this push-pull tension between marketers and lawyers relating to advertising promotion. Clearly, the marketing folks, their goals are to capture consumer attention and to tie into consumer sentiment and desire, right, to help generate more revenue at a higher profit. From the legal side, we don't want to be known as the voice of no, just the voice of reason and, frankly, known risk assumption. We see our job as helping to identify potential problems and help mitigate risk and possible loss. So, how will the marketing claim be judged as to whether it qualifies as a false advertisement? Well, there's several different legal tools that complaining parties can use, but frankly, they're all pretty similar. In general, the standard relates to whether the statement is likely to mislead or deceive a reasonable consumer acting reasonably under the circumstances. But as the FTC puts it bluntly, the advertising at issue must tell the truth and not mislead consumers. The trick bag for us is to figure out what message is your labeling and advertising sending to that proverbial reasonable consumer. And to be sure, it's not just words that can trigger a claim. Imagery you use in your packaging and promotion can also be a part of a claim, suggesting you are emphasizing certain understandings of potentially vague or ambiguous words by visually trying or tying into a preferred or perhaps inconsistent meaning to the consumer. So it's the total packaging of promotion, right? A bit of death by a thousand cuts approach as to how we are seeing today's more nuanced claims in this field. Understand that creative and aggressive plaintiffs' lawyers are forever on the hunt for new theories under which to bring these lawsuits. And frankly, the ingenuity of those folks in this area, it never ceases to amaze me. So what I would like to do now is to go through kind of what I call the W's, the three W's, the who, the what, and the where. And let's start with the who, and that is, who is our source of concern in regard to these claims? We have three big buckets of potential claimants. The first is going to be your customer. These claims generally come in the nature of consumer class actions, and the claims are generally that they were misled into thinking that your product was something other than what it turned out to be, or perhaps they paid a premium for your product because of a particular statement that, according to them, ended up being untrue. The second bucket of potential who is your competitor. Now, generally, competitor claims are comparative or disparagement type claims, and we'll talk about that in much greater detail later. And last but not least is the regulators. Now, when I think of regulators here, I usually think of the Federal Trade Commission, but there are a number of state regulators, including attorneys general, that get involved in this dance, particularly out in California. So while we're on the FTC, or the regulators, who are these cats, the FTC? This is way too simplistic, but I see the FTC kind of as acting as the FDA's pit bull, although they do a lot of stuff on their own. The remedies that they have include stop orders, like an injunction, monetary penalties, and corrective advertising, just to name a few. And to be sure, understand that the plaintiff's attorneys watch the FTC and what it does like hawks. There's almost a symbiotic relationship between the FTC, the regulators, and the plaintiff's bar, where the regulators, allow the plaintiff's bar to kind of be the enforcement arm, that the regulator identifies the issue and the plaintiff's bar takes it from there. Now that you know the who, let's talk about the what. And I'll break these down by your three buckets of who. Let's start with the consumers. Consumer claims are largely based on statutory schemes directed to deceptive trade practices. Every state's law are different, but frankly, they're more similar than they are different. Consumer class actions almost always include warranty claims as well, suggesting that your advertising warrants a particular aspect or attribute of your good or service at issue that, according to them, ends up being untrue. What about competitor claims? They're almost exclusively based on the Lanham Act. And like state law claims in consumer cases, they're also adjudged in general on a reasonable consumer acting reasonable standard. There is an aspect of likely to cause confusion. Even though that confusion is viewed from the consumer's viewpoint, its impact has to be felt by the competitor in these claims, usually in the way of lost sales. Now let's talk about the what for competitors' claims. As I indicated earlier, claims by competitors are usually in the nature of comparisons or negative statements about their product. And as Emily will address, substantiation really is the name of the game here. And finally, I want to talk about the where. If you do get a claim that's brought against you, where will you be defending your action? Well, as to all, generally, courthouse is an appropriate forum. In competitor claims, there's also another option, and that is to complain about your competitor's advertising before the NAD, the National Advertising Division of the BBB, Better Business Bureau. Those folks are exceedingly skilled in addressing comparative and disparagement type claims, and perhaps the best source for insight for folks like us as to how other triers of fact should come down on particular issues. And as to the regulators, in addition to the courthouse, they obviously have warning letters and they have the ability to initiate agency type actions to do their dirty work. So now that you know the who, the what, and the where, I'd like to turn the mic over to Emily to address what we call regulated claims and how to steer clear of.
Well, thanks, Mike. So now I'm going to jump into, what claims have regulations and how those regulations might be able to help you in a litigation context. So specifically, we're going to dive into some of the claims that FDA regulates. We're really going to focus kind of on the food and beverage as well as dietary supplements claims. But, these are the general buckets of claims that FDA regulates, nutrient content claims, structure function claims, specific types of health claims, including qualified health claims, drug and disease claims. And then they also have kind of a catch-all for certain miscellaneous claims, like fresh, natural, which is regulated by guidance by FDA, and has had a whole host of litigation surrounding that James will talk about a little bit later. And then also there's some regulation over imagery on your products specifically. So to talk kind of about the continuum of the different claims that end up on food products, your first category are generally nutrient content claims. And these characterize the level of a nutrient in a food. So as you can see here, we're using the example of calcium in different products and what that kind of claim would look like. Potentially on a dairy product, you would use something like good source of calcium. And you can see that it's characterizing the level of calcium, and good source is something that's specified in the regulations as allowed for use. And, really says the amount of it that's in the product. Other claims like no added sugar and healthy are also considered nutrient content claims by FDA. And the big thing that you need to know is that in order to use those claims that are outlined in the regulations, you really have to follow the regulations to a T. There are very specific amounts for you to say whether it's a high source of a certain nutrient or a low source of a nutrient. Moving on to structure function claims, they're kind of the next step that gets you closer to a health or disease claim. And these categorize the role of a nutrient or a substance on the structure or function of the body. And these are really on, these claims, you kind of get closer towards that health claim, but you're not getting into that realm because you're focusing on a healthy person and the normal function of the body. Where we see a lot of companies get tripped up is where they make implied references to diseases or unhealthy states of the body. And if you want a quick course in what those kinds of enforcement looks like, look at any of the hundreds of, warning letters that FDA and the FTC have issued to cannabidiol companies recently. Some of those, yes, look at adulteration of the product related to the presence of cannabidiol, but a lot of them them really hone in on the structure function claims going too far afield. As you can see in our example here, calcium builds strong bones. Your body is operating normally, but you're building extra strong bones with calcium. Next, into qualified health claims, which is kind of a subset of health claims. Both those categories are, specifically outlined by FDA and require FDA approval prior to their use on a food. They look at the relationship of a food or a substance and its connection to a disease or a health-related condition. In this case, we're talking about calcium. And these are specifically, again, outlined in the regulations or in a qualified health claim, acknowledgement from FDA. And the difference between a qualified health claim and a health claim is that the qualified health claim includes just what it sounds like, a qualification. It says studies suggest but don't prove, and then, the description of the nutrient or substance and that health-related condition. The health claim, on the other hand, doesn't have that kind of qualification. It just says this nutrient may reduce the risk of this disease or health-related condition. Now, on the other hand, drugs, which is, a highly regulated category and requires a lot of FDA pre-market approval before introduction to the market, are really focused on statements that discuss any kind of diagnosis, treatment, mitigation, cure, or prevention of a disease. And in this case, you can see our example says that calcium prevents osteoporosis. And drug claims can only be on products that are drugs. And that, like I said, requires quite a bit of pre-market approval. So, these are kind of the continuum of the main types of claims that FDA regulates on foods, beverages, dietary supplements. There are also cosmetic claims that really focus on, brightening of the skin and hair and those kinds of things that regulators look at and, are things that you want to market on your product, but really need to follow what the strict definitions are. Another area in the food and beverage space that we've seen a lot of scrutiny over recently are flavor labeling lawsuits. Specifically related to vanilla has been the largest area recently. And flavor labeling is extremely complicated. It's honestly one of the most complicated parts of the food labeling regulations in my mind. Part of that is because there are 6 different categories of flavor labeling, and it all depends on, are you using natural flavors? Are you using a natural flavor with other natural flavors? And that really means that there's kind of additional flavorings that are used to simulate or enhance what is known as the characterizing flavor. And in those vanilla litigation, they kind of focused on this issue that's in the last bullet point is, how are you depicting and declaring the presence of a flavoring on your label? A lot of those statements would say, flavored with natural vanilla. But then in the ingredient statement, they would only say natural flavors. And that's completely allowed under the FDA regulations. But the issues in that litigation kind of popped up saying, well, are you actually using just vanilla? Because if you are, you should say vanilla extract. Or are you using something that's an other natural flavor? Or are you actually using synthetic vanilla flavorings? And another area where we've seen this pop up as well is in smoked provolone. In some instances, provolone is actually smoked, and there are requirements in, the cheese standard of identity that deals with non-smoked provolone. And others also are including smoking through use of a smoke flavor. And you can see that these are kind of 2 different examples on the, what's in the market. One is an actually smoked provolone. The other is a smoked with added flavor. And, those obviously are, some people get confused by those potential labels on products. So it's really important to see where that flavor labeling regulations may be able to help you, because some of those vanilla cases, a lot of it falls on the misleading to a reasonable consumer, but compliance with the FDA regulations has been helpful so long as they're meeting those requirements, and then also are kind of making sure that the depictions also of flavors are not, contradictory to the regulations. Another area that we're seeing a lot of interest in people marketing on are place of origin claims. Some of this is tying into people wanting to source products, more locally or from U.S. manufacturers. But there are also some regulatory requirements that are a little bit different than, oh, this product was assembled in the US, so I can say it was made in the United States. Specifically, if you're importing any product, whether it is, a cosmetic, a piece of clothing, syringes, or even a food, Customs and Border Protection has specific rules on country of origin that can get complicated, but those need to be looked at to ensure that your product is actually, based on, labeled correctly using those requirements. USDA also has specific country of origin labeling that is mandatory for certain products like fruits and vegetables. There's also, an area that we've seen a ton of litigation and interest in, especially surrounding President Biden's Buy American and Build Back America, focused on locally U.S. sourced products, are these Made in USA claims. And both the Federal Trade Commission and the state of California have pretty stringent requirements around labeling products as Made in USA. There's one specifically unqualified claims where you just say this product was made in the US, it was manufactured in the US, anything like that. And that can only be made on a certain limited subsect of products that are all or virtually all made in the US and not have US sourced ingredients, not just from a US supplier, but the ingredient is actually from the United States and has a US country of origin. So it's really a very narrow use of that term, except for qualified claims where you can have statements like made in the U.S. from domestic and imported ingredients, or assembled in the United States from domestic leather and foreign steel, or something like that. There's a lot of flexibility in that, but the FTC does have very specific requirements that they're actually in the process of revising right now. Additionally, TTB has appellation for wine requirements. So again, you really need to know the regulations that may exist as you kind of try and make these place of origin statements. But as James is going to discuss later, it's a little bit more than just what statement did you make on your product about the origin and some of the other things that you could imply on your product, and where we've seen some litigation around that. Another area that we see a lot of interest in are kind of humanely raised or animal raising claims. And I mean, the FTC and FDA really don't have any specific requirements that apply to most goods that have an animal origin or an animal source. But so those claims must be truthful and not misleading and meet the reasonable consumer standard. There is one exception in FDA where they do have some requirements regarding RBST-free claims. But, we're seeing more and more where customers are looking for information about how livestock products or livestock sourced ingredients are raised and the treatment of those animals. When your product comes from something that maybe is from a meat, poultry, or egg product, USDA does have guidelines on allowing and having, some backup information regarding, whether you're making those statements or actually bearing a certification on your product. So if you're looking to just kind of get some federal guidance for a product that even falls out of that, they do have some information on what might be considered humanely raised or, ethically raised or something like that in the context of an animal sourced product, even if it doesn't specifically apply to, the product that you're trying to sell. Another area that I get so many questions about are what I call as green claims. You may call environmental claims. Some people may call it greenwashing. And these are claims like biodegradable, compostable, recyclable, those kinds of things. The FTC does have what's known as the green guides. These have been in existence for quite a while. And they make some recommendations on not using overbroad claims, making sure that things are, not unqualified, and you really focus on the specific environmental benefit that you're trying to portray with your products. They also have some guidance regarding certifications in there and what those mean, but the big thing that FTC really focuses on in that guidance is that if you're making any of these claims, while they do have some, guidance on what compostable and what degradable means, that you really need to find and have competent and reliable scientific evidence to support the specific claim. But also know that other states like California, Washington, and Maryland specifically have requirements on plastic products that are marketed as compostable and actually refer to a specific ASTM standard that basically helps you make that reliable and competent evidence to support those claims. So now let's look a little bit on how do you actually comply now that you maybe know that a regulation exists on your product. The first thing that you need to do is know what regulations maybe exist to, verify a claim or help support a claim or how you can make that claim. That's really, really important because, as James is going to discuss later, if you're actually potentially in compliance with that regulation, you do have a good argument potentially for primary jurisdiction or preemption. It also helps you, stay in compliance with those regulators to avoid any enforcement there, because if you're throwing healthy, for example, on a product and not meeting the FDA healthy requirements, you can run into some enforcement from the agencies. Additionally, we highly recommend that you consider tailoring your claims and making sure that you look at your labels and marketing as a whole to not just look at the specific statement, but make sure that your advertising isn't implying something more than you claim. And the biggest thing that you always need is substantiation in order to support those claims. You've verified what your claim is trying to say and what you mean and what it implied is saying. Do you have evidence to back that up? And that evidence is all going to vary depending on the type of claim that you make, exactly what you need in the level. And in some cases, like with health claims, FDA has a specific health claim standard that you need to meet in order to show that you verified those claims. Another area where we're seeing our clients and really everybody kind of trying to use as a support for their substantiation are third-party certifications. And these are really great, where a third party establishes a standard that you can follow. And we've, just put up an example of some of the ones that exist for a wide variety of products. But I will say there is one of these that is fake. So as you look at this, slide, you should take some time and, enter in the chat box which one you think isn't actually a real certification. And, we're kind of using that to demonstrate that anybody can set up a certification, and some of them are good and well vetted and very robust, but at the same time, they may not actually mean something or have the same meaning that a consumer has for a product. And James will tell you, in his presentation that these certifications are great, but they're not always the silver bullet that some people think they are, because you've had this third party come in and say, you meet this standard, whether a term is defined or not by a regulation. I think we're going to continue to see a lot more of these pop up to meet some of these claims. And it is nice when it's a third party who's doing the certification, but it doesn't mean that you are actually in compliance with any standards or that, you can 100% avoid litigation. Now, Mike talked a little bit about, how agencies have the ability to enforce as well, and kind of what should you expect or what should you do? Obviously, you need to, if you've done all the things that we'll discuss, that we've discussed, doing kind of marketing reviews and other things, and you have your substantiation, you should be able to respond to the agency. But you should also expect that, especially if that enforcement is made public, either through the posting of a warning letter or, one of the FTC actually brings a case against you, either administratively or in court, just definitely know that those are something that plaintiffs' attorneys watch extremely closely, and it helps them kind of tee up where you're not in compliance with regulations and, may need to have suit filed against you, which is something that I'm going to turn over to James now to talk a little bit about, kind of the litigation landscape and what we've been seeing there.
All right, thanks, Emily. Everyone, I'm James Spung. I'm a partner in the commercial litigation group here at Husch Blackwell, specializing in complex litigation, including class actions and mass action defense. And so I'm happy to be here to talk today. I'll be dividing this into two parts. The first is to a few recent developments in class action defense. And the second part is a very brief high-level review of some of the claims that we're seeing crop up in the courts. So the first one comes out of the 11th Circuit. So what are incentive awards? There's something that show up in a lot of class action settlements, actually, as a way to pay the named plaintiff Every class action has at least one of those. They're the ones with their name actually attached to it. And the incentive award to the named plaintiff is usually some smallish amount, such as $5,000 or so, that gets paid out of this class action settlement when it settles, if and when it settles, for the trouble of being a plaintiff, essentially. If you're a plaintiff, you're subject to investigation, to discovery, to deposition, all, very unpleasant. And that supposedly compensates the named plaintiff for that. Now, $5,000 doesn't seem like a whole lot, but it is usually a lot more than all the other class members get. Now, according to the 11th Circuit, and by the way, these have been in a part of class action settlements for decades and decades, but according to the 11th Circuit, in a case last year, they found an ancient Supreme Court case that the 11th Circuit said incentive awards are entirely illegal. And the quote from the court was, "So far as we can tell," I'm quoting, "incentive awards exist as a product of inertia and inattention and not adherence to law." And so the 11th Circuit struck down a settlement that used one. And I think that quote that I just said is a theme we're starting to see in at least a few courts as they approach class action litigation. We'll get to that next. But so the fallout from that, will class actions decrease? This was an intriguing case. It came out of left field. And the answer to that is we're not sure. In theory, it should, because you lose one big reason why people sign up to be a named plaintiff. Without named plaintiffs, there are no class actions. So it's too early to tell, and we're keeping an eye on it, but it certainly gives us an interesting tool in negotiating settlement. And I guess the other question is, will the trend catch on? If what the 11th Circuit is saying is right, you would think you'd see it blow up around the country. I would say so far, we're looking at it, it's not really been the case. A number of courts have actually declined to follow this, and they have elected to try to figure out how to maintain the status quo and allow these class actions to settle the way they always have settled, by including, largely by including an incentive award. So we'll see what happens there. The second development that I want to highlight comes out of the 9th Circuit. Some background here. First of all, the 9th Circuit is the West Coast of the country, known for being a hotbed for this type of consumer class action litigation. And the 9th Circuit, kind of surprisingly, just gave class action defense lawyers like myself a big sharpened tool, big sharpened arrow in the defense quiver, as I put it on the slide. So at class certification, judges are supposed to conduct what's called a rigorous analysis. And what you see a lot of times that is frustrating is from the defense perspective is, well, sometimes they don't seem to. They don't resolve clashes between expert witnesses, for example, on, let's say, how damages can be calculated or how liability can be proven class-wide. Another one is when, the defense side will offer evidence that there's a healthy majority, but a healthy portion of the supposed class that hasn't experienced any injury. But sometimes that gets swept aside by courts too, just in the game usually is the court will look at that and say, well, that's not to be decided now at class certification when the court has to actually approve the class. That can be decided at some later stage of the case. Of course, by the time you get to that later stage of the case, you've already spent millions of more dollars sometimes, wasted a lot more time getting to that point, and only to find out a lot of times that it should have never been certified as a class action to begin with. So what did the 9th Circuit do? It's had a lot of interesting things that are helpful for us, but the two predominant holdings are, number one, a court has to resolve expert clashes. So when you have one expert saying something, one expert saying contradicting that first expert, a lot of courts have been getting by saying we don't need to resolve it now. The 9th Circuit made it pretty clear in this opinion, no, you got to resolve it. You have to deal with an expert that's saying you can't calculate damages. You have to deal with an expert that says you can't prove liability on a class-wide basis. You have to deal with that at the certification stage and not later. That's a really helpful thing for the defense side. Another one, then the other holding, I guess, the second holding, is that uninjured members, if the defense offers evidence that there are uninjured members of this supposed class, the court has to actually address that evidence and make sure that the uninjured members aren't de minimis, meaning the court said about 5%. If you get more than 5% of your class being an uninjured class member, then that's going to present a problem and perhaps a barrier to class certification. So, like I said, it sharpens an arrow. It gives us a beefier tool in our toolbox. These aren't new arguments, but they're arguments that a lot of courts have ignored, that I would think after this case, this Ninth Circuit case that I'm talking about, has been handed down, I think it would be a lot tougher for courts to ignore that type of argument. And if courts are forced to actually resolve expert clashes or forced to actually deal with the evidence that we try to put up on the defense side at class certification, that could bode well for us. The other question about it is, will it hold? It was a big enough deal that a judge on the Ninth Circuit said on his own that he thinks the Ninth Circuit should consider rehearing the case. And now the parties are briefing as to whether the Ninth Circuit should rehear the case. So we'll see what happens. I'm not sure, frankly, what's going to happen. The Ninth Circuit is one of the most unpredictable out there. And so we'll see. But the takeaway here that I'm seeing, that I sense, is that oddly, this might be kind of similar to the 11th Circuit case in that basically some things about how a court treats class actions has been getting by as a result of maybe what you might call inertia or inattention, to quote the 11th Circuit, and maybe not as a result of adherence to law. Another takeaway, I guess you might think about is the Ninth Circuit starting to get maybe a little bit tired of being the load bearer for these types of cases? I don't know. That's maybe wishful thinking on my part, but we'll have to just see. The last one is arguably the biggest potential development out there for class actions, at least in federal court. It starts in 2017 when the Supreme Court decided a case called Bristol-Myers Squibb. Now, that was a mass action. That's a bunch of individual cases that are consolidated, bundled together in one court, in one state for only certain purposes. And that's no matter where the plaintiff of every case is from, no matter where the defendant is based, no matter where the claim happened. And so these mass actions traditionally have been getting by in one federal court, regardless of if the defendant was actually properly under that court's jurisdiction. And the Supreme Court came in and said, and this was a little bit of a sea change, the Supreme Court said that a federal court does not have jurisdiction over a defendant company in these mass actions where neither a plaintiff, a claim, or a defendant have any connection to that state. So remember, it's a bunch of individual claims consolidated together. And so what was happening is, while some claims might properly be in that court, a bunch of others were not, but as a matter of administrative convenience, the court was just proceeding anyway. The Supreme Court said, no, you can't do that as a matter of jurisprudence. And so what that did is effectively kill the nationwide mass action, at least outside the defendant's own state. And it's a largely positive development for mass action defense. Interesting for mass actions, even more interesting for class actions. But the question becomes, does it apply to class actions? It seems logically like it should, but, and we've made that argument before, sometimes successfully, sometimes not. But courts have been grappling with that since 2017. And everyone's sort of waiting for the Supreme Court to take it up again and actually give people some guidance, give especially the courts some guidance as to how to deal with this. Their first chance happened in January this year in a case out of the 7th Circuit that's in the middle of the country. And on this one, the Supreme Court said, nah, we're not going to take up the case. You district and appellate courts continue to gnaw on it, continue to grapple with the issue, and maybe sometime in the future we'll deal with it. So it remains an open question. It's certainly a decently effective tool in our toolbox in class action defense, and one we anticipate continuing to use in the future. So part two is, like I said, what we're seeing in the courts. And there's a lot of different things I could talk about here. We don't have all day. We're trying to keep this well within an hour. And so I'll just limit it to the three main categories I find most interesting. That is in the cases that are cropping up in court right now. So the first, I would call it a quality or cleanliness claim, for lack of a better term. The original seems to be natural. You keep thinking it's going to fade and it doesn't. So natural has been around for almost 20 years now, and I don't see it going anywhere, frankly. But that's old news. There are newer spin-offs of the natural type of claim that we call trigger words. Trigger words are those words where they appear in packaging. They seem to mean something to consumers, but nobody's sure what. And they're certainly words that a creative plaintiff can find ways, lacking any sort of definite understanding of the term. Creative plaintiff's lawyer can find ways to arguably prove it inaccurate or wrong. So an example would be premium or healthy or nutritious or something free, cruelty free, for example. These are all examples of trigger words that we see crop up over and over, including recently in litigation. And as Emily mentioned, a lot of these have become pretty regulated. And where there's regulation and where you're complying with regulation, there's always the potential for what's called a preemption defense, meaning you can point to the government to either say, we met the government definition and that's enough, or we met the government definition and we could not have at the same time done what plaintiff says we should have done. Those arguments are a lot of times good ones. They're about as close as you can get to a silver bullet, but oftentimes they don't work. And there's still room for a court to say, yeah, you met the government definition, but your label or advertisement is still misleading, or at least arguably misleading to a reasonable consumer. So even if you comply with regulations, there's still room for a lot of times there's still room for plaintiff's counsel to argue you into court. I would put it that way. Other examples are something based, so plant-based. We just saw a company get recently sued for mineral-based sunscreen, despite that it allegedly contains harmful chemicals. There was also another company that actually wasn't able to get a lawsuit dismissed, and that lawsuit was over a plant-based cleaning product where they weren't made exclusively from plants. So we anticipate we'll continue to see those types of claims. The next category of claim that I wanted to raise was origin claims. We heard Emily talk about that a little bit in her segment. And I wanted to raise that a little bit too from the litigation standpoint. Origin claims are the claims where a company says, or at least implies, that a product is from a certain place. They can be literal, they can be statements, or maybe more interestingly, they can be indirect statements, or even just images like Mike and Emily have both mentioned. So as far as the actual statements of origin, the made-in claims, those are highly regulated, subject to preemption defenses a lot of times. But remember, it's not always a kill shot. And sometimes you have to grapple with whether a statement is actually misleading to consumers. And so there's a recent example of a tea company in federal court in California. Their key claim was manufactured in the USA. Problem is, only a little bit of the tea packet was actually manufactured in the USA, and that survived dismissal within the last couple months, meaning they have to proceed into discovery. Now, a note on that, the tea company did put a little bit of a clarifying language on its packet. The clarifying language said, and I quote, blended and packaged in the USA. And the argument at the dismissal stage was, well, Your Honor, we said blended and packaged in the USA, so that should clarify to the consumers that it wasn't fully manufactured in the USA. And the court said, that's interesting, but that clarifying language is not enough to dispel the overall impression created by you just saying manufactured in the United States. And that underlines what I would take away as a general rule with asterisks in clarifying language. And that is that asterisks on product labels can clarify, but they can't correct a lie. They can't correct a false impression. And when they do, courts are going to get mad at you, and plaintiffs are going to have a heyday with that type of claim. So that brings us to implied origin claims, what I'll call implied origin claims. And that's perhaps even more interesting development in recent years. Could also be called companies misleading claims as to a product's quote unquote authenticity. So in other words, even if a company doesn't say something in words, overall impressions can matter, and they can imply something that isn't true. So one example would be Hawaiian rolls. They say the word Hawaiian several times on their packaging. And they've got, they even say that they say Hilo Hawaii on their packaging as well, but it turns out it's actually manufactured in California. And the claim, they got involved in litigation. The claim is, well, you say you have implied that originated in Hawaii when in fact it did not. Icelandic skyr as a type of yogurt. That's another product that got called into court over this. And notice they never say it was manufactured in Iceland. They say Icelandic provisions. They say traditional skyr. In another part of the label, they say made in, designed, I'm sorry, let me look, developed in partnership with a dairy in Reykjavik. And this is something else they pointed to, getting back to the imagery point. The plaintiffs in that case pointed to the imagery of what they call the idyllic Icelandic countryside on the packaging, all to give the distinct impression that it is coming right out of a dairy processor in Iceland, when in fact it's not. It actually is made in New York. Those cases are still in progress. It'll be interesting to see where they go, but I think they underline some interesting points to be aware of for marketers and companies who are putting out products and services to consumers. The last category is what I would call the literally false or literally true yet still misleading type of claim. Historic examples would be the foot-long sub that isn't actually a foot long. That might be literally false. Another one would be 2x4s, the wood product called 2x4s, which is not in fact 2 inches by 4 inches. And we've seen this in a number of recent examples in the last few years, some of which we've been involved in. One is saying a product has a maximum horsepower of X and letting a plaintiff say, well, I tried it at home and turns out I couldn't ever get that horsepower. Another one is data storage. If you buy, say, a portable hard drive and it says it has 10 gigs of data storage on it, but it only has 9.5. That's a claim that's landed a few companies, including, say, Apple, in court. Net weight is another interesting one that we've seen show up as sort of a new rendition of slack fill cases. In other words, a company will say that their bag of chips has a net weight of X, and somebody will take them to court saying, well, the bag is way bigger than the actual volume of the chips involved. Company tries to say, well, but then we told you what the net weight is, so that should fix it. And just within the last month, we've seen a court say, you know what, net weight is not enough to dispel the impression that a big bag full of not so many chips gives you. Number of servings is a type of claim we've seen in court. Last year, we saw a spate of them against coffee companies. Folgers was one, where basically the number of servings just didn't add up. The math didn't add up, or you were making really weak coffee if you wanted to get the number of servings that it took. And that landed a number of coffee companies in court, and a lot of them are still there. And finally, one we saw most recently is protein content or any sort of quantifiable nutrient content. As plaintiffs, remember, they are creative, and as they get more and more creative and more access to scientific studies, they can try to prove your nutrient content. So how many protein, how many grams of protein, I should say, does your product have? How many grams of fat does your product have? They can try to find ways to prove those wrong and prove those false and misleading. And that can land you in court, as it did with the company just within the last 30 days. So that wraps up my section, and I will, I'll go ahead and invite Mike and Emily to come back in. We're going to do a little roundtable.
All right, we're back. So in this section, we wanted to kind of open it up as a roundtable and to talk to you guys about what do we see that's out there on the horizon, a glimpse into the future, if you will. We don't have any slides for this section, but slides are available where we address these topics. You can click on the resource folder icon at the bottom of your screen. So what do I see? So James will tell you that anybody that's been paying any attention to me for the last year, I keep saying, I think the next natural is sustainable. What I think we're seeing is marketers attempt to tie into public sentiment relating to social or corporate responsibility. Emily, how about you? What are your general thoughts here?
So, Mike, I totally agree with you. The problem with sustainable, as anybody will tell you, is there isn't really a definition or a standard definition for it. It's not necessarily specifically defined by FTC or any agency, and many people look at it more than just environmental sustainability. If you talk to any corporate sustainability person, they're going to tell you it's based on 3 pillars of environment, social, and economic. So is that what we're able to actually say specifically about any of our products? And then how do you substantiate that? Because it's a pretty broad claim. And that's something that, the federal agencies may take issue with if you don't have it really tuned in specifically. Are you talking about the products being sustainable or the packaging being sustainable, or is it both?
Right. So, James, from a trial lawyer's perspective, I see the danger here is what Emily's laid out in the nature of the vague and ambiguous term. And it's vagaries that will provide the plaintiff's bar with the impetus to use it and try to beat back marketers. You?
Yeah, I think that's right. From a litigation perspective, we've already seen this crop up as recently as a couple months ago. A case in a federal court involving a sustainable claim on smoked salmon that actually is settled in 2 months. I don't know, but it seemed like a difficult one to defend simply just because, as you say, there's no definition. And so it's sort of up to the plaintiff's bar to interpret it as they will. And when the plaintiff's bar can interpret a term, there's a lot of ways to make it inaccurate as far as the product's label goes.
Yeah, it's going to fall into that a reasonable consumer acting reasonably under the circumstances. Kind of, what does it mean to them?
Yeah,
I know that case. I'm familiar with that case. They had some interesting facts that might have encouraged settlement as well. Kind of as an adjunct to this, what about ethically sourced? I think, Emily, that also is one of these efforts to tie into public sentiment on social responsibility.
It absolutely is. And I mean, we're seeing a lot of issues in the ethically sourced space already. Does it mean fair labor standards based on who is manufacturing your product? We've seen some palm oil cases related to that, and cocoa and a few others. There's also, a lot of fair trade standards, for example, that are set up. And by the way, if you didn't guess it, the fake third-party certification was Raised with Care certified, the one with the chicken symbol on it. And those certifications can help, but a lot of the questions lie on whether or not that's actually what a consumer thinks that term means, even if it's bearing a certification or a verification claim from some third party.
Yeah, I absolutely agree that the certification aspect, or the rise of the third-party certifier, is just saying, you fit my definition, not that you fit what the consumer understands that to be. And you're going to have to go the extra mile to educate the consumer into what your definition is. And James and I have had to deal with that in other matters. James, what about ethically sourced?
Well, I had one thing to keep in mind, too. I was actually going to make a comment on the third-party certifiers. It's a little bit like complying with a government regulation or agency regulation, but without the protection of a preemption defense, because that's going to be specific to the government. So you can maybe say, well, I complied with this third-party certification, but when a court looks at it, it's going to say, so what? What does the consumer think? And then you land yourself in hot water. I think you're absolutely right, too. Ethically sourced could even sustainable. The word itself could actually somehow mean ethically sourced if consumer, if the plaintiff's counsel can make that argument. And if you look at it and say, I say sustainable, you say it means ethically sourced, how do you disprove that? I'm not sure. So I think we're going to see that come out in the courts in the next few years.
All right. Well, thanks. That's all the time we have for this. We'll take our questions next. And we're back again. We do have a few questions. I encourage everybody to pile questions in, several of those related to Emily's fake certification mark. She's already answered that for you, so we'll skip to a very interesting one. Is there a practical line we can draw between puffery and other claims? And this is a great lawyer answer. I'm not sure. Puffery, for those of you that don't know, is the type of claim that everybody knows. Everybody knows that this isn't making some type of a warranty about the product itself. Best coffee in the world. How are you ever going to measure that? But I will say that there are things that you can do to push your suggestions, your marketing and promotion towards puffery that provides you more ammo to defend against the claim. By way of example, use humor. The more, Red Bull gives you wings. Does it give you wings, really? James might say, well, that sounds like a literally false claim, but it's so crazy that nobody really thinks that it's going to give you wings. It's a suggestion that it's going to help you with energy supply, which Emily might then take a crack at from the food and beverage side. And Emily, while we're here, this is one for you. In the food and beverage space, what type of claims do you see as the most risky at this time?
So, I mean, I would love to say all claims. As James has pointed out, you can comply with regulations and then there's some additional or new interpretation that, a plaintiff's attorney has. But where we're seeing a lot of litigation is around where, my client or, just really any food and beverage company wants to make a claim about what I'll call like a healthy-ish claim. So whether it's the term pure or just a tad of, and trying to just a tad of sugar or slightly sweetened, but the product contains a lot of added sugars or, just those kind of like light healthy things or complete nutrition. That's a new one that we saw. I think people are trying to step outside of the regulations, which is absolutely okay. It's just then how are you able to back it up and substantiate it? James will tell you probably litigation can get filed on anything, but, we're trying to be more creative and, we still end up with litigation because you can file a lawsuit on anything.
God bless America. So another question, interesting one. Have we seen a real drop off in the number of made in the USA suits or claims in California? I would have to say no. The weird thing about this is made in the USA has an FTC definition, also has a California definition because, of course, they have to be different than everybody else. They're very similar, but there are some differences. Emily, I know I've asked you to handle a number of these claims for clients. What's your take on it?
Yeah, I mean, and I think a little bit of the question is, are they being filed for suit in California? And I'll let James talk about that piece since he knows where suits are more likely to be filed than not. But the California standard has been slightly more harmonized with the FTC standard. So we're seeing less suit under the California standard, but quite a bit under the FTC standard. And it is one of the areas of very active enforcement by FTC themselves. We don't see a ton of false advertising cases there. Most of them are done through consumer class actions, but they have had some massive settlements and in their enforcement proceedings recently, totaling like millions of dollars for companies that are viable or patently false made in America claims.
All right, James, we have a couple minutes.
About the California piece? Like where people are filing suits?
Yeah, well, I mean, if general rule of thumb is if you want to file a consumer class action, you go to California if you got any hook to get there. The honest answer is I don't know if we've seen a drop off. I certainly still see them, and even though despite the increasing regulation over that term and the harmony between California and the federal government, I think there's still this. You'll have a preemption defense like I talked about, and you could even have some other kinds of defenses about if the government is thinking about a certain angle for made in USA type of claims. You could say, well, you got to wait. You can't do anything in this case until the government actually does something additional. But as far as the actual number, the sheer number of cases involving made in USA claims, I don't know if they're dropping off. I think I'm with Mike. I don't think so. I think the plaintiff's bar is just that creative.
It's just like every time we think natural is over, there's another series of natural cases.
I saw one get filed yesterday. I saw a natural case get filed yesterday. Yeah.
Well, James, while we're on you, if a company is literally wrong on some objective fact in their marketing, like horsepower, you talked about that, or net weight, are they dead to rights in consumer case, or is there some path to victory?
It's certainly not the best starting point if you've got those facts coming in the door, but you know, there are certainly ways to defend that claim as well. We've done it, and in some cases are still doing it. I think, you know, off the top of the head, I guess the playbook would be, first of all, what is the actual literal wrong, and is there some way to make a preemption argument or a primary jurisdiction argument out of that? In other words, whatever you're saying and whatever the plaintiff would be saying is wrong, is it still right according to some like government agency definition? Or is it still right according to a third-party certification type of definition that you can point to and say, we were using this certification? That's I know Emily talked about that. And third, and probably most importantly, what all these cases come down to is, even if it's literally wrong, what does the reasonable consumer think? Does the reasonable consumer expect it to be dead nuts on, as Mike would say, or does the reasonable consumer allow some sort of flexibility with this actual literal falsehood that makes it so that it's not actually misleading? And I guess I would also throw in there another thing that these cases often come down to is, where is it filed, unfortunately?
Yeah, that's the unfortunate aspect. Am I going to win or lose? Well, you know, where did you get served? Bad way for us to start the conversation. All right, guys. Well, this has been exceedingly interesting, at least in my books. We're just a scotch over our time, so I think we ought to pull the plug here. If you folks submitted a question and we didn't get to it today, don't worry. We'll provide you a direct response by email or reach out. If you go to the resources folder, you will be able to find the presentation slides. And if you actually look to the end of those presentation slides, we threw in a couple bonuses. They are under the heading of avoiding advertising claims, to give you some tips about how to kick the tires on your promotional materials or your labeling kind of in advance of putting it out there. If you have more particularized questions that we didn't get here today, feel free to pick up the phone and give us a call. We'll do our best to help you. And again, I want to thank everyone for joining us today. We hope the information was helpful to you and your organization. As a reminder, this program has been approved for continuing legal education hours. And so to report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. And again, sorry to ask, but please complete our short survey. We do use this feedback to help put together future programs. And with that, that concludes our webinar. Thank you for joining us, and have a great rest of your day.